In the abstract, property is that which belongs to or with something, whether as an attribute or as a component of said thing. In the context of this article, property is one or more components, whether physical or incorporeal, of a person's estate, or so belonging to, as in being owned by a person or jointly a group of people or a legal entity like a corporation or even a society. Depending on the nature of the property, an owner of property has the right to consume, alter, share, redefine, rent, mortgage, pawn, sell, exchange, transfer, give away or destroy it, or to exclude others from doing these things, as well as to perhaps abandon it, whereas regardless of the nature of the property, the owner thereof has the right to properly use it, or at the very least exclusively keep it. In economics and political economy, there are three broad forms of property: private property, public property, and collective property. Property that jointly belongs to more than one party may be possessed or controlled thereby in very similar or very distinct ways, whether simply or complexly, whether equally or unequally. However, there is an expectation that each parties will with regard to the property be clearly defined and unconditional, so as to distinguish ownership and easement from rent. The parties might expect their wills to be unanimous, or alternately every given one of them, when no opportunity for or possibility of dispute with any other of them exists, may expect his, her, its or their own will to be sufficient and absolute. The restatement of property defines property as anything, tangible or intangible, whereby a legal relationship between persons and the state enforces a possessory interest or legal title in that thing. This mediating relationship between individual property and state is called a property regime. In sociology and anthropology, property is often defined as a relationship between two or more individuals and an object, in which at least one of these individuals holds a bundle of rights over the object. The distinction between collective property and private property is regarded as a confusion since different individuals often hold differing rights over a single object. Important widely recognized types of property include real property, personal property, private property, public property and intellectual property, although the latter is not always as widely recognized or enforced. An article of property may have physical and incorporeal parts. A title, or a right of ownership, establishes the relation between the property and other persons, assuring the owner the right to dispose of the property as the owner sees fit. Overview. Often property is defined by the code of the local sovereignty, and protected wholly or more usually partially by such entity, the owner being responsible for any remainder of protection. The standards of proof concerning proofs of ownerships are also addressed by the code of the local sovereignty, and such entity plays a role accordingly, typically somewhat managerial. Some philosophers assert that property rights arise from social convention, while others find justifications for them in morality or in natural law. Property, in the first instance, is a thing in itself. When a person finds a thing and takes that thing into that person's possession and control, then that thing becomes a thing for you for that person. Once the person has that thing in that person's possession, that thing becomes that person's property by reason of discovery and conquest, and that person has the individual right to defend that property against all others by reason of self-help. Typically, persons join together to form a political state which may develop a formal legal system which enforces and protects property rights so that the individual can go to court to get protection and enforcement of that person's property rights, rather than having to use self-help. It is possible that when a person has constructive possession of personal property, but another person has actual possession, then the person having constructive possession has bare legal title, while the other person has actual possession. Generally, the ground and any buildings which are permanently attached are considered real property, while movable goods and intangibles such as a copyright are considered personal property. Also, property cannot be considered a reified concept, because in the first instance, property is very concrete as a physical thing in itself. Various scholarly disciplines may treat the concept more systematically, but definitions vary, most particularly when involving contracts. Positive law defines such rights, and the judiciary can adjudicate and enforce property rights. According to Adam Smith, the expectation of profit from improving one's stock of capital rests on private property rights. Capitalism has as a central assumption that property rights encourage their holders to develop the property, generate wealth, and efficiently allocate resources based on the operation of markets. From this has evolved the modern conception of property as a right enforced by positive law, in the expectation that this will produce more wealth and better standards of living. However, Smith also expressed a very critical view on the effects of property laws on inequality. Wherever there is great property, there is great inequality. Civil government, so far as it is instituted for the security of property, is in reality instituted for the defense of the rich against the poor, or of those who have some property against those who have none at all. In his text The Common Law, Oliver Wendell Holmes describes property as having two fundamental aspects. The second, title, is the expectation that others will recognize rights to control resource, even when it is not in possession. He elaborates the differences between these two concepts, and proposes a history of how they came to be attached to persons, as opposed to families or to entities such as the church. Classical liberalism subscribes to the labor theory of property. They hold that individuals each own their own life. It follows that one must own the products of that life, and that those products can be traded in free exchange with others. Every man has a property in his own person. This nobody has a right to, but himself. The reason why men enter into society is the preservation of their property. Life, liberty, and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty, and property existed beforehand that caused men to make laws in the first place. Conservatism subscribes to the concept that freedom and property are closely linked, that the more widespread the possession of private property, the more stable and productive is a state or nation. Economic leveling of property, conservatives maintain, especially of the forced kind, is not economic progress. Separate property from private possession, and Leviathan becomes master of all. Upon the foundation of private property, great civilizations are built. The conservative acknowledges that the possession of property fixes certain duties upon the possessor. He accepts those moral and legal obligations cheerfully. Socialism's fundamental principles center on a critique of this concept, stating that the cost of defending property exceeds the returns from private property ownership, and that, even when property rights encourage their holders to develop their property or generate wealth, they do so only for their own benefit, which may not coincide with benefit to other people or to society at large. Libertarian socialism generally accepts property rights, but with a short abandonment period. In other words, a person must make continuous use of the item or else lose ownership rights. This is usually referred to as possession property, or usufruct. Thus, in this usufruct system, absentee ownership is illegitimate and workers own the machines or other equipment that they work with. Communism argues that only collective ownership of the means of production through a polity will assure the minimization of unequal or unjust outcomes and the maximization of benefits, and that therefore humans should abolish private ownership of capital. Both communism and some kinds of socialism have also upheld the notion that private ownership of capital is inherently illegitimate. This argument centers mainly on the idea that private ownership of capital always benefits one class over another, giving rise to domination through the use of this privately owned capital. Communists do not oppose personal property that is hard-won, self-acquired, self-earned by members of the proletariat. Both socialism and communism distinguish carefully between private ownership of capital and private property. Types of property. Most legal systems distinguish between different types of property, especially between land and all other forms of property, goods and chattels, movable property or personal property, including the value of legal tender if not the legal tender itself, as the manufacturer rather than the possessor might be the owner. They often distinguish tangible and intangible property. One categorization scheme specifies three species of property: land, improvements, and personal property. Dead investment property. It is a property from which you cannot derive any profits. Scenario: the property might be not in a suitable condition to use or cannot be used to earn profits. Investors also say that the properties where we stay are dead investments. In common law, real property is the combination of interests in land and improvements thereto, and personal property is interest in movable property. Real property rights are rights relating to the land. These rights include ownership and usage. Owners can grant rights to persons and entities in the form of leases, licenses and easements. Throughout the last centuries of the second millennium, with the development of more complex theories of property, the concept of personal property had become divided into tangible property and intangible property. Treatment of intangible property is such that an article of property is, by law or otherwise by traditional conceptualization, subject to expiration even when inheritable, which is a key distinction from tangible property. Upon expiration, the property, if of the intellectual category, becomes a part of public domain, to be used by but not owned by anybody, and possibly used by more than one party simultaneously due to the inapplicability of scarcity to intellectual property. Whereas things such as communications channels and pairs of electromagnetic spectrum band and signal transmission power can only be used by a single party at a time, or a single party in a divisible context, if owned or used at all. Thus far or usually those are not considered property, or at least not private property, even though the party bearing right of exclusive use may transfer that right to another. Related concepts of the following: only sale and at will sharing involve no encumbrance. Violation. Miscellaneous action issues in property theory. What can be property? The two major justifications given for original property, or the homestead principle, are effort and scarcity. John Locke emphasized effort, mixing your labor with an object, or clearing and cultivating virgin land. Benjamin Tucker preferred to look at the telos of property, i.e., what is the purpose of property? His answer: to solve the scarcity problem. Only when items are relatively scarce with respect to people's desires do they become property. For example, hunter-gatherers did not consider land to be property, since there was no shortage of land. Agrarian societies later made arable land property, as it was scarce. For something to be economically scarce it must necessarily have the exclusivity property, that use by one person excludes others from using it. These two justifications lead to different conclusions on what can be property. Intellectual property, incorporeal things like ideas, plans, orderings and arrangements, are generally considered valid property to those who support an effort justification, but invalid to those who support a scarcity justification, since the things don't have the exclusivity property. Thus even ardent proprietarians may disagree about IP. By either standard, one's body is one's property. From some anarchist points of view, the validity of property depends on whether the property right requires enforcement by the state. Different forms of property require different amounts of enforcement. Intellectual property requires a great deal of state intervention to enforce. Ownership of distant physical property requires quite a lot. Ownership of carried objects requires very little, while ownership of one's own body requires absolutely no state intervention. Some anarchists don't believe in property at all. Many things have existed that did not have an owner, sometimes called the commons. The term commons, however, is also often used to mean something quite different. General collective ownership, i.e., common ownership. Also, the same term is sometimes used by statists to mean government-owned property that the general public is allowed to access. Law in all societies has tended to develop towards reducing the number of things not having clear owners. Supporters of property rights argue that this enables better protection of scarce resources, due to the tragedy of the commons, while critics argue that it leads to the exploitation of those resources for personal gain and that it hinders taking advantage of potential network effects. These arguments have differing validity for different types of property. Things that are not scarce are, for instance, not subject to the tragedy of the commons. Some apparent critics advocate general collective ownership rather than ownerlessness. Things that do not have owners include ideas, seawater, parts of the sea floor, gases in Earth's atmosphere, animals in the wild, celestial bodies in outer space, and land in Antarctica. The nature of children under the age of majority is another contested issue here. In ancient societies, children were generally considered the property of their parents. Children in most modern societies theoretically own their own bodies but are not considered competent to exercise their rights, and the parents or guardians are given most of the actual rights of control over them. Questions regarding the nature of ownership of the body also come up in the issue of abortion, drugs and euthanasia. In many ancient legal systems, religious sites were considered property of the god or gods they were devoted to. However, religious pluralism makes it more convenient to have religious sites owned by the religious body that runs them. Intellectual property and air can be property in some senses of the word. Ownership of land can be held separately from the ownership of rights over that land, including sporting rights, mineral rights, development rights, air rights, and such other rights as may be worth segregating from simple land ownership. Who can be an owner? Ownership laws may vary widely among countries depending on the nature of the property of interest. Persons can own property directly. In most societies, legal entities, such as corporations, trusts and nations, own property. In many countries, women have limited access to property following restrictive inheritance and family laws, under which only men have actual or formal rights to own property. In the Inca Empire, the dead emperors, who were considered gods, still controlled property after death. Whether and to what extent the state may interfere with property under United States law, the principal limitations on whether and the extent onto which the state may interfere with property rights are set by the Constitution. The Takings Clause requires that the government may take private property only for a public purpose, after exercising due process of law, and upon making just compensation, if an interest is not deemed a property right or the conduct is merely an intentional tort. These limitations do not apply, and the doctrine of sovereign immunity precludes relief. Moreover, if the interference does not almost completely make the property valueless, the interference will not be deemed a taking but instead a mere regulation of use. On the other hand, some governmental regulations of property use have been deemed so severe that they have been considered regulatory takings. Moreover, conduct sometimes deemed only a nuisance or other tort has been held a taking of property where the conduct was sufficiently persistent and severe.